So I have Sandy Lundy with me today, a very experienced appellate attorney. Sandy, thanks for coming on today.
Thank you, Jason. It's such a pleasure to be here.
So Sandy, as you know, we're trial attorneys and we do a lot of criminal cases, but we don't really see what happens to a criminal case after we're done with it, right? So where you focus a lot on terms of appeals, can you tell us a little bit about how the appellate process actually works?
Sure, I'd be happy to. First of all, everybody has a right to appeal, at least in the first instance, to the appeals court. So everybody has a right to appeal if they've lost their case or lost a part of their case, which is really important to know. It's also important to know that the appeals court is really different than the trial court. You've got a three-judge panel sitting on the case, and all they're looking at is the record. All they're looking at is the written words that are being said. They can't tell if anybody's smirking or whatever. They're looking at the documents that were in front of the judge, and they're looking at some of the pleadings that were submitted. And they're looking at that body of evidence, and they decide whether the judge or a jury made a mistake that was so bad that it may have affected the outcome of the case. And if it did, they may vacate the ruling, they may send it back for another trial or trial of a part of the case. Or if they find that there's no error, then they affirm the case.
So what happens when? So I had a couple questions with that. What happens when you have a client who really wants to argue things that are outside of the record? Like, oh, I wish my attorney argued this, or I had that, and it didn't come up, and we didn't get to that chance to do that. What happens in that situation?
Well, the court can only look at the record. The appeals court will only look at the record. That person might have an ineffective assistance of counsel claim or some other claim, but the appeals court will look at the record and only the record.
I see. And then what about if you have a situation where you don't agree with the decision of the appellate court and maybe they made a mistake? What type of recourse do you have from there?
Well, there are two ways to go. First of all, when you get a decision that goes against you, you want to appeal. Most people go to the appeals court where you have every right to be to appeal your case. Some people, there are three levels of courts in Massachusetts: Supreme Court at the top, Supreme Judicial Court, the appeals court, and the trial court. Some people say, I want to try to go right up to the highest court in the Commonwealth, the Supreme Judicial Court, and they will make an application to the court to say, will you reach down in the appeals court and take my case up? So sometimes the highest court in the state will directly take your case. Sometimes if you lose at the appeals level, you have to petition the Supreme Judicial Court and say, that not only did the appeals court make a mistake, but the appeals court made a mistake that affects not just this case, but a whole bunch of cases. And
Right.
for that reason, it's important enough that you should weigh in on whether this decision was right or not. And then if the Supreme Judicial Court grants the petition, then they essentially review the case again.
So say if let's even bring that into a more complicated posture. So then the SJC doesn't take your appeal, or if the SJC doesn't rule in your favor, then you can keep going to the higher court, the federal court at that point, or how does that work?
Well, you have to have a federal claim, you know. I
Right.
mean, and if you have federal claim, you might start in the appeals, you might be in the federal court. I'm just talking about Massachusetts and Massachusetts state law.
Right.
Federal court is a whole other court system. And sometimes if the Supreme Court rules on a matter of federal law, the Supreme Judicial Court, you can go to the federal system. But that's not that rarely happens. More in criminal law, certainly almost never in family law, or other land use or things like that.
We'll definitely have you come back to talk about that process, the federal process, some other day. I know they're very different. I would love to hear your thoughts in terms of that. But also, there's the single justice. So when do people go to the single justice instead of the full panel regarding the appellate court? What are the situations that people would appeal there?
Well, you would go to the single justice if you were in the middle of a case and the court made a ruling that could potentially affect the outcome of the case in a way that would really prejudice you if the case, had to go all the way through. In criminal law, a lot of times it has to do with the introduction of evidence. Was this admissible or not admissible under some constitutional principle? So, Fourth Amendment, I think, is a big one. But you could take an interlocutory appeal. It's called an interlocutory appeal in the middle of the case. Whenever there's an order that basically essentially knocks out a cause of action or makes it almost impossible for you to proceed successfully in your course of action. Right. And those are just heard by one single justice. But if you don't like what that single justice did, you can appeal to a wider panel of the appeals court. Yeah.
Now, because it is a single justice, are people getting a hearing faster where they're just doing an interlocutory appeal where when it comes to the full panel it can take a longer period of time?
Generally, an interlocutory appeal takes less time because in a full appeal, you've got to get the entire trial transcript. You've got to get all of the exhibits that were in front of the judge that you want the appeals court to look at. You've got to get, the pleadings. Just to compile the record could take a good, sometimes 4 to 6 months. And it's not you that compiles the record because we could do it a lot quicker, but the trial court has to compile the record and send it up to the appeals court. They may have one clerk in charge of appeals in a court in which they've got 50 or 60 pending appeals. So the person gets to it when they get to it, and it could be a very long process.
Right. Sandy, we definitely want you to come back to talk about federal appeals next, but appeals isn't the only thing that you do. You also do a lot of family law.
That's right. I do a lot of family law, anything from divorce, paternity, restraining orders, adoption, the whole gamut of family related disputes. I've been doing that for a long time too. I've been doing everything for a long time.
And Sandy, tell us a little bit about the climate right now, where the courts are still really closed for the most part in terms of moving things along. How's it going on in that world?
It's tough. It's really tough on the clients. Let's say you have somebody that's in desperate need of alimony. I had a case today. We put in a motion 3 weeks ago, and we got a hearing date in June. I mean, what's the woman supposed to do between now and June? Wow. Today being April 6th. So, the cases, and if you want a trial, you might have to wait. You might have to wait months and months beyond that. You may have to wait for 9 months, and then get one trial day and wait 4 months to get another trial day. So the courts have been slammed with COVID. They can't catch up. I'm not blaming anyone. It's a really tough situation.
Well, it sounds like they should definitely reach out to you and figure out the best way possible to deal with their cases. So thank you for coming on today. I would love to have you come back soon and tell us more about your experience and just kind of how the way things work in the world.
Thanks, Jason. I really enjoyed it. Take care.